Make your way across the country aboard Amtrak. Take in the majestic views from big picture windows and large, comfy seats that elevate your trips to the next level. From dining cars to private rooms, you can make memories in comfort. Capture amazing moments with picture-worthy views. Learn more at Amtrak.com. Amtrak. Retrain travel.
When you manage procurement for multiple facilities, every order matters. But when it's for a hospital system, they matter even more. Grainger gets it and knows there's no time for managing multiple suppliers and no room for shipping delays. That's why Grainger offers millions of products in fast, dependable delivery, so you can keep your facility stocked, safe, and running smoothly. Call 1-800-GRAINGER, click Grainger.com, or just stop by. Grainger, for the ones who get it done. When you manage procurement for multiple facilities, every order matters. But when it's for a hospital system, they matter even more. Grainger gets it and knows there's no time for managing multiple suppliers and no room for shipping delays. That's why Grainger offers millions of products in fast, dependable delivery, so you can keep your facility stocked, safe, and running smoothly. Call 1-800-GRAINGER, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
Content warning, this episode contains discussion of the murder of 2 girls.
Well, today was what we presume to be the final pretrial hearing in the Richard Allen murder case. And the trial itself, with the opening statements, is scheduled for tomorrow. It was a shorter hearing, but it was an interesting hearing. For one thing, for the first time this week, both James Luttrell and Stacey Diener of the prosecution team spoke in court.
Yes.
So we can tell you about that and about a whole lot more.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is The Delphi Murders, Richard Allen on trial. One last pretrial hearing.
I'd like to start, if it's okay with you, Anya, by actually jumping back to before today's hearing, to yesterday, when I guess Judge Gull issued a couple of orders. And one of those orders in particular caused a lot of confusion in some quarters.
Yes, a lot of confusion, and a very unfortunate amount of confusion. So Judge Gull issued an order around an offer of proof around
Odinism. And this made some people think that Odinism was back in the trial, and it's not. So let me try to explain what exactly this means. As we all know, back in the 3 days of pretrial hearings in July and August, the defense very badly wanted to convince Judge Gull to allow Odinism as a defense in the trial. And she said no. But she did say they would have an opportunity to do an offer to proof. And these offers of proof are basically a way for the appeals court, should there be an appeal, to be able to evaluate the testimony that would have been offered. Because it would be very hard for a lawyer to to make an appeal to the courts and say, well, this testimony from Joe Smith really would have saved my case, but the judge didn't allow it, because then the court would say, well, what was this testimony from Joe Smith? So you make these offers of proof outside the presence of the jury for the record, for an appellate court potentially to look at. And so what the judge did at the request of the defense, in order to save time, the defense basically said, we want to just incorporate all of the testimony from that 3-day pretrial hearing and make that part of our offer of proof. And if you do that, if you are willing to accept this earlier testimony and the transcripts and what have you of that, that means we don't have to take a day out of the trial to bring those people in again to offer the same testimony. And that's what she agreed to. And so because of that, nothing really changes, and some time is saved. And
it's just everyone showing their work, essentially, so the appellate court can decide, hey, Judge Gull made an error here, or no, she was right to leave this out, right? And it's a convenience thing.
It's a convenience thing, because the appellate court needs to know what exactly it was she ruled was not admissible.
But unfortunately, the majority of journalists, and I'm a fortunate journalist because I happen to be married to Kevin Greenlee. I'm fortunate for that for many reasons. But also, Kevin is a lawyer. And when I read something like this and I'm confused, I can ask him and say, wait, is Odinism back in? And he can say, no. Read it again. And I could say, yes. Or more likely, he's just going to explain it to me. But a lot of journalists, they're writing things on the fly. They're interpreting things. They do not know how to read legal documents, which can be hard to parse sometimes and written in sort of a different language, almost the language of legalese. And a lot of people misinterpreted this and then ran with it. And that happens sometimes. It's unfortunate. And it's just, people are rushing and they're trying to get information out, and that happens sometimes. And it's not really one person's fault. It's just, it's an unfortunate occurrence, especially when you're dealing with something like this. So all the headlines that you saw about Odinism's back in, were not correct. And that was a mistake.
So Judge Gull also issued another order yesterday. Are we ready to move on to that?
Yeah, I guess speaking of the press, yeah.
So also speaking of this 3-day hearing, there was this 3-day hearing where there was a lot of items admitted into evidence, a lot of exhibits. And typically, when exhibits are entered into a case, they are available for the public to view. There's a public record of it. And so after this hearing, some members of the press made a request to view the exhibits from this hearing. This is, again, very, very standard. And they made this request on, well, I'm going to read from this document that Judge Gull prepared. Quote, at the conclusion of the hearing on August 1st, 2024, the court took the matter under advisement. The court indicated it would take approximately 30 days to issue its rulings on the multiple motions which were heard. The media immediately on August 2nd, 2024, demanded access to the exhibits. This was an unreasonable request, as the court had just taken the matter under advisement the previous day, and the court needed absolute access to the exhibits to review and make a ruling, end quote. She mentions they're needing 30 days to make these rulings about the matters that were the subject of the hearing. And I make the obvious note, it's now the middle of October. So she certainly has had time. She's had well over 30 days to make the rulings and then take care of this request from the media to view the exhibits, which again is a very reasonable request. She, for some reason, calls it an unreasonable request. And I think that really highlights something we've been talking about lately, which is Judge Gull and her Allen County outfit or team or whatever you want to call it. Not only do they don't take seriously any obligation to share their work with the public. pretty much any other court we've worked with, public access has been more of a priority. I'd say most judges realize that it is very important that the public have access to the work they are doing, because judges have an awful lot of power in our society. And it is important the public get a chance to review what they're doing. And law enforcement has a lot of power in this society, and it's important that we get a chance to review it. So I was surprised that Judge Gull referred to this request for public access to these exhibits as unreasonable.
Yeah, the whole ticked off tone of it really was, surprising that she put that in a filing. Feels like, I guess we're all human, right? Maybe something is like, oh, they're already asking for this. But you don't have to write that. You can just, think that and then write a blander filing, which would probably be the smart thing to do. I guess it's just like, the press has a job that is different from the judges, but I think it's also very important. And the press is going to ask for things, and they're going to ask for things in a timely manner. And, I feel like that's just sort of the nature of being a journalist, right? Like it's, they're not going to be like, oh, well, let's give the judge a break, a few days off. You're going to ask for it right away because now you might be able to access it. And to be expressing some level of anger for journalists doing their job just seems like a weird decision to put in a filing. I don't know why you're kind of expressing exasperation or ire about that. It's the job of the press to do this. And if there are good reasons to delay it or not give the press everything they want, I'm not saying you have to do that. But kind of complaining about people doing their jobs, it's just, I don't know.
And I would go a little bit further and say judges are educated people. We would expect them to have an understanding of the importance of public access.
Yeah. And again, the press, you may like the press, you may hate the press, you may feel ambivalent about the press. It's a situation where in cases like this, the press can be a stand-in for the public, because every member of the public is not going to be able to go to this trial, but media reporters can, and they have huge platforms on which they can broadcast information so that you can learn about what's going on. So when you're making it very hard for them to do their jobs, it means that the public typically gets less information. And you can beat up on the reporters. You can say the reporters are bad, or they're getting stuff wrong, or they're doing this and that. Yeah, okay, fine. But at the end of the day, it means when they're getting kind of, treated like this, and things are not given to them, then it's not just affecting them. It's sort of
affecting all of you.
Yeah, it affects the public.
I'd like to read the next paragraph and make a couple quick points about it. Again, this is from an order from Judge Fran Gull. Quote, "The court would note that this murder case is one of over 300 pending cases on this court's docket, with approximately 30 of those cases being murder cases. The court and the court reporter have worked into the evenings and on the weekends to comply with the demands made by the media," end quote. So first of all, she says, the first sentence, there's an element of self-pity in here, it seems to me. The first sentence basically seems to suggest that I'm working so hard on these other cases, you shouldn't expect me to fulfill my basic requirements on this one. And to that, I don't find that a compelling argument for many reasons. One of which is that the Indiana Supreme Court has indicated that they are willing to give Judge Gull whatever help she needs with her caseload so she can adequately manage this.
Yes.
So this is, and if she, even with that help, if she finds it too much that she's not able to fulfill her basic obligations to the public, maybe another judge should have been found. And secondly, she says that she and her court reporter have been working so hard to comply with the demands made by the media. We will get into this a little bit later, but I want to say that no one in the media feels like Judge Gull and her team has been responsive to their request for public access.
No.
So I don't think anyone feels that she and her team have been working into the night to comply with demands. Speaking
to journalists who are covering this case, that's pretty much a consensus that this is an unusually restrictive case in terms of media access. No one's talking about, wow, this has been great. We're really getting a lot of consideration here. And, you know, I understand from a human level why one would feel overwhelmed dealing with suddenly such a high profile case, all this attention, all these media requests. That's a lot. But first of all, you can have feelings and then not put them in your motions. And you can also, as Kevin said, do something else.
Yes.
So
I really, I don't want to say
let's
that.
move on.
Yeah, let's move on. I'm going to skip a couple of paragraphs. The court has, quote, the court has obtained the services of a senior judge to supervise the review of these exhibits to make them accessible to the media. This judge has indicated she will make the exhibits available to the media on Tuesday, October 22nd, 2024 at 10 a.m. at a location in the Allen County Courthouse located in Fort Wayne, Indiana, end quote.
Interesting timing.
So basically, the people who would be most able to understand and appreciate what the significance of those exhibits will be in Delphi that day at the trial. And she is making those pretrial exhibits available in Fort Wayne a couple of hours away. That doesn't really seem terribly helpful. And the last sentence, quote, the media is also demanding access to the exhibits which will be introduced at the trial commencing October 18th, 2024 to November 15th, 2024. At the conclusion of each trial day, the court will allow the media access to those exhibits for 15 minutes, end quote.
When we started the Murder Sheet, we didn't really know if podcasting was even going to work out for us in the long run. Like, what if no one listens to us? That would be awkward. I'm really glad we tuned out those doubts and went for it, because it's been an absolute dream come true. But the kind of uncertainty we face is what stops people from betting on themselves, chasing their dreams, and starting their own businesses.
For all of you out there looking to kickstart your own dreams, partnering with Shopify is one of the best decisions you can make. It gets you on the right track from day one. They take the uncertainty out of business.
Shopify is your one-stop commerce platform that supports millions of businesses around the world.
Shopify makes you efficient and fast. You can upload new products, improve existing products. Shopify's AI tools can help you with product descriptions, page headlines, and better product photography.
And don't worry about nobody buying your products. They help you get the word out. Shopify puts the power of a whole marketing team behind you. You can create email and social media campaigns with just a few clicks.
Shopify supports you with inventory management, international shipping, processing returns, and more. Whatever the challenge, they're there to make things quicker and more convenient. It's time to turn those what-ifs into with Shopify today. Sign up for your $1 per month trial today at shopify.com/msheet. Go to shopify.com/msheet. That's shopify.com/msheet.
You know what it reminds me of, Kevin? People sometimes get mad at journalists for requesting a comment. You know, it's like you might be doing a story that could be perceived as negative of someone on somebody, and you reach out to them and say, I'd like to give you a chance to comment. And, you know, it's not pleasant to have a negative story done on you, right? But ultimately, the journalist is doing their job, and the journalist is actually doing their job by contacting you to say, I want your side of the story so I can incorporate that and be fair. And like people complain and get mad about it. And it's just like, that's just part of the job. And in fact, it's a good thing to get both sides. And it's like, this feels like, you know, she's complaining that the press wants access to the exhibits. That's their job, A. And B, enhancing the public understanding of the case is a positive thing. Okay. I mean, like, I don't understand why there's this disconnect where it seems to be that essentially everyone interested in the case is lumped together as a big nuisance, when in fact, if you have responsible journalists reporting on the case, that can help tamp down some of the conspiracy theorists that we've seen cause a lot of problems. Yes. So, you know, it's like, but instead it's like everybody's a problem. And I don't think that's fair. And I don't think it's good for public access.
And she's treating people who want public access like they are kindergartners making demands. I think this sort of thing makes the legal system in Indiana look really, really awful in the eyes of the world.
Also, I want to just stress, ask any Indiana reporter who's covered crime. This is not this is not something that I've seen in Indiana before. This is not something I think is an Indiana thing. This may be an Allen County thing, but it's certainly seemingly in this situation a Judge Gill thing. So like, I don't want people to, I mean, geez, I think back daily to our experience with the Kegan Kline case with the pretrial hearings in Judge Timothy Sparr's courtroom. And, gosh, he had a media section. He was, explaining everything. He had decorum orders. It was all very clear cut and accessible. And we appreciated that. And I think other people appreciated that too. I mean, I don't think there's typically this level of, frankly, what feels like at times hostility to the media.
Yes. More than at times. If you talk to reporters covering this case, it feels like every one of them has some kind of a horror story about their dealings with Judge Gull. And we think at this time, maybe we should give you ours. And as you hear this story, just keep in mind, we're telling it because it's our story. But a lot of people have had bad experiences with Judge Gull, and a lot of people are frustrated by the lack of public access and transparency.
Yeah.
And a lot of people are upset by the conflicting messages sent by this judge. Conflicting messages even on trivial things. The judge has said in the courtroom, if you want to leave to go to the restroom, you can. Just you're not allowed back in. And then she will yell often at people who stand up to go.
Especially towards the end. I mean, when you say yell often, there's two instances that have happened. So let's clarify that. There's two instances, both that happen at the end of court that day. But it's like, if it's okay to do normally, like there's no clear directions often given at the end, where I can understand if she wanted to say, hey, everyone in the gallery sit down, let the jury out first, or, something like that. Like, but don't tell people it's generally okay to get up as long as you don't come back, but then get mad when people get up at the end because they think it's over. Like, giving clear instructions would be the way to deal with that. But I think it's important to clarify. It's not like there's
that is true
constant screaming matches. But it has been troubling because I just feel like that's something that I don't think people generally want to get in trouble or cause a problem. In most cases, I'm sure in some, maybe that's not true, but I think it's better to just explain things, explain what you want people to do, and then act accordingly. It does feel inconsistent to say it's generally okay to get up, but maybe you could say at the end, just stay seated until I, say court's dismissed or whatever. I want to say also, we want to talk about this because it's our experience, but also because to me, it's one of those things where if it just happened to us and everything else seemed fine, I don't think we'd talk about it because it would just be like, well, maybe we just have really bad luck. But because we feel it ties into some of these media public access goings on, we felt we needed to say something because we can attest to some of this firsthand, even if our experience is a little bit different than everybody else's. And I just want to say also, I think we're going to talk about this today. And then I think we're going to probably not talk about it for a while, or at least only allude to it, because I want to keep the focus of our trial coverage on the trial, not on the media or the public access issues. I mean, we could probably talk about them in even more depth at another time, but I really want the facts on this case.
I do too. We're going to do our best to get in every day. I think that's where the focus should be now.
Mm-hmm.
With that said, I feel very strong feelings about this, and I have a lot to say about it, and I will do that after the trial is over.
Yeah, that's fair. And, it'll be, I think, maybe I don't know. I feel like there's a lot of textbooks to be written on this case about what not to do in certain instances. And I think in terms of a courthouse, a courtroom, handling a high profile case, there's definitely a lot to be said. And yeah.
So this story involves press passes. Anya and I have been covering this case for a while. I think, frankly, we've done some great coverage.
I think we've broken a lot of different stories. Our reports have been cited in local media, in regional media, in national, international media. We're frequently called upon as experts on different programs. I feel like the fact that we've been cited widely in the media is a testament to the credibility and the strength of our reporting, and the fact that we are doing journalism. We're journalists with a podcast. A podcast is our platform, but we are ultimately vetting things with multiple sources, seeking out documents, reporting on things, getting things corroborated. We filed into the case at one point in order to get a bunch of documents released. We've really tried to be committed to the fundamentals of journalism throughout this process.
And the Indiana Supreme Court recognized that, and they gave us press credentials back in January. So we applied for press credentials for this trial, and Judge Gull denied it. And she denied it because she felt that a podcast didn't count as press.
And we strongly disagreed with that because we'd also been credentialed by the Indiana Supreme Court, and they thought our argument that we were an outlet and we were publishing and we could qualify as some sort of periodical. They took that seriously, but we also do know it's up to the judge. Typically, these are not like statewide decisions; these are local matters. So even though we strongly disagreed, we understood and we sort of expected this. We weren't surprised when we got denied outright, and we said, okay,
And you say it's up to the judge, but I will note, and I'll note this again, that many times in the orders the judge filed about this, she indicated that the decision and the process would be made by the media, and she did not want to be involved.
I'm talking about like when we're talking about who's considered media in Indiana. Right. It's typically up to the judge or whatever judge in the county. So if the judge finds a local podcaster to be credible media, they might say, right, yeah, you are media, and if not, then you're out of luck. So
we disagreed with her decision, but we
understood it,
accepted it.
Yeah, we accepted it.
So the next thing that happened was we got an opportunity to work with a magazine publisher, and a magazine publisher counts under the Indiana statute as media.
Yep.
So we reached out to Judge Gull, assigned this process for some reason to a person who has no experience whatsoever with media.
Nope.
Don't know why she picked him. I'm not sure he knows why he was picked. But he looked at that. He looked at the credentials we got, that these people were interested in working with us, and he said, this counts. You are eligible for these press passes. So great news.
We're back in.
We're back in.
We're so back.
And then the press passes at this time were to be distributed on a first come, first served basis on a Friday morning. So on Thursday morning at about 9:30, we get an email from this character. Well, first of all, let me say that when we were writing back and forth with this person who works with Judge Gull about the podcast issue, we said, we don't know if Judge Gull will consider a podcast as media. And he said, well, no problem. I'm in really steady contact with Judge Gull, and I'll just ask her. So he's working very closely with Judge Gull. So back to the story, on the Thursday before the press passes were to be distributed, he wrote to us a very short, terse email where he said, on second thought, this magazine that wanted to work with us, they didn't count under the statute, even though they plainly did. A magazine publishing regularly counts.
It's print. It's printed out. That's in the statute. That's it.
So we wrote back, why doesn't this count? And he never deigned to reply. So then we decided, well, we really want these press credentials. And so we made some phone calls. We had a good relationship with the Franklin Daily Journal, which is an excellent paper. Excellent paper. And they said, well, guys, we'd love to have you cover it for us. And of course, we're a daily newspaper. That's obviously covered by this statute. And so we said, that's great. And we wrote to this person that Judge Gull picked to handle it. And we wrote him, I believe, at 11:24 a.m., about 2 hours after he nixed us for no good reason.
And made a request saying we're going to be requesting again, but with a different outlet. And this is a newspaper based in Indiana.
And it's called the Franklin Daily Journal. And he wrote back and said, that's great. That counts. You're in. And then a couple hours later, he wrote back and said, oh, by the way, it's no longer going to be first come, first served. It's going to be a lottery.
And we were like,
and
what?
We said, why are you making this change? He says,
it's fairer this way. Okay, well, whatever.
Okay, so then we have cleared our schedule and made plans to go on this Friday to Fort Wayne to get these press passes. And that morning, he sends us an email that says, no, you were supposed to get your request in by noon the previous day, and you didn't do that, so you don't count. You're not good enough to get this press pass. And again, we had actually made the request at 11:24 before noon. So he's out and out.
Well, I mean, he said basically that the editor of the, basically blamed like, well, the editor didn't email me before noon, but he had already told us we were in, and I took it that we needed to make a request on behalf. It seemed thin.
It seemed to be a situation where they were trying hard. It seemed to be a situation to me, I'm going to phrase this carefully, where this person was making decisions he thought were rational and common sense, and then someone else was telling him no and trying to find reasons to exclude him.
Yeah, it seemed like a lot of searching for pretext, frankly. And, from there we were like, well, okay, well, we're not going to get any. But, I mean, we're still working with the Franklin Daily Journal. So, I mean, we're doing some articles for them. It's exciting. I enjoy
it. And again, it's a
writing
great
them.
paper.
Yeah, and you should check those out, by the way. Just like, we're still going to do that throughout this whole trial. We're going to do the podcast, but also do some articles, because the Franklin Daily Journal is the paper where two of the 6 attorneys based in this case are from Franklin, Indiana. They practice there. They're well known there. This is a hometown story for them.
So it's very
we
legitimate.
will be working hard to get them the coverage that they deserve.
So back to the story, I think it was yesterday. Judge Gold did some sort of an order, or maybe it was the day before, where she did some sort of order where she said basically, this press pass process, I'm washing my hands of it. The press passes that we didn't get, by the way, were for jury selection. The press passes for the trial.
Oh, yeah, let's explain that because people are confused.
Okay.
So jury selection, 5 press passes to any number of outlets. That was chosen through a lottery. We missed out on that as described. There were supposed to also be 12 press passes distributed for trial, and those were divided into a couple of different categories based on print versus radio versus television. And it's more complicated than that, but that's all you need to know. There were supposed to be 2 separate lotteries.
So the jury selection one was the one we weren't eligible for. Now Judge Gold is saying this thing about press passes for the trial itself, I'm just basically washing my hands of it. I'm letting this professional person who knows about the media, who works at WTHR, I'm letting this person handle it and make her own decisions. And so we reached out to that person, and that person, by the way, very kind, professional,
responsive,
competent, kind, wonderful, a person who gives you answers and sticks by them. And this person said, you obviously count as media. The Franklin Daily Journal obviously deserves to have representatives there. So as far as I'm concerned, you're in. But keep in mind, Judge Gold has the right to remove you. And so this morning, before the press passes were issued, I won't go into too much detail, but we learned that Judge Gold herself personally intervened to make it possible for the Franklin Daily Journal and for us not to receive press passes. And I want to just say I find it disturbing that a judge who has all sorts of outstanding motions on her desk and who, as she mentioned in her order, has all these other cases, that she is taking the time to personally decide which press outlets she wants to include and, more importantly, which press outlets she wants to exclude. I could speculate about why she wants to exclude us, but maybe that we can do that after the trial.
Mm-hmm.
But I find it disturbing, and I don't find it to be a good use of the power of a judge.
Yeah. I mean, it was pretty surprising, but maybe I guess I wasn't surprised at this point, but it was an experience, and it's not lost on either of us that in an email Judge Gold once said, based on what seemed to be some kind of very dire misunderstanding of the leak that occurred a year ago, that we should be put in jail.
And that was based on her having a total misunderstanding of the facts, a misunderstanding so great that rather than being angry with her, I was almost embarrassed for her because it showed how little she understood about the actual facts of a trial she was running, or a case she was running at that point. Never heard from her since if she regrets those words or if she stands by them. But they reflected the fact that she didn't know what she was talking about. And I know since then, some people have told us they tried to explain to her the actual facts. I'm not sure if that message ever sank in.
Well, I think we have our answer now. And I'm just going to say, yeah, this has been eye-opening. And to be clear, in case you're wondering, well, how did other people feel about you guys joining the press pool? All the journalists we talked to a lot of them. We talked to people in print and newspapers, all sorts of things. They were very welcoming, very kind, very accepting.
People were very happy we were included.
Yeah, we didn't hear any complaints. I mean, we were kind of worried. We were like, maybe people are going to be mad because we're going to be taking a seat, but nope.
People earlier were frustrated that we had been left out.
Well, some people were. I'm sure some people might have been like, well, that means I might have a bigger chance of getting in more days. But the thing is, like, nobody was like, oh my God, keep them out. Like it was very welcoming. It was very, I think people understand that, like, we've helped move this story forward again and again. So, I mean, I think.
And a lot of the people whose stories you see on television or read, we've talked to. Sometimes they have questions about the case.
Yeah.
So they know us, they respect us.
And they also know the Franklin Daily Journal, and they think they deserve a seat at the table.
And I find it disturbing, too, that Judge Gold didn't stand by the words of her order, because she indicated that this process would be run by the media, and the media decided they wanted us to be a part of the team. And Judge Gold did not stand by her words. She intervened in the process.
So the way that this works is, by the way, just like, every couple of days, they'll kind of rotate people in and out of the media seats. So nobody's going to get to cover the whole thing through that way. It's going to just be a rotation. Any other days, people will have to stand in line. So, we're missing out on that, but we plan to just continue to hit it from the public angle, and that's what we're going to do. But I think, given all that's happened with the media, and frankly, the way the press has been treated in this situation, and the way the public access in general has been treated, we felt it was important to let you know what happened with us, because it's been a pretty surprising road that, I mean, to be honest, in the beginning, I was like, well, we're a podcast. We're not going to get credentialed. And I was okay with that to a certain extent. Like, I accepted that. I guess I wanted to try hard. I didn't want to just say, like, well, we're just going to give up now, because I like to try hard about things I care about. And I felt like on some level we deserved something. I felt like on some level we could do some cool opportunities, even if we had to work with a print outfit to get there. But I felt like, this could be good. And it was disheartening, not because necessarily the outcome, because I expected that. It was just the process felt very, very arbitrary, random. And we were frequently being told, yes, yes, yes.
You're definitely in.
Just kidding. And that yo-yoing, it just,
This was like 2 weeks of our lives. We spent a lot of time on this.
But it's like, why? Because it felt like it was arbitrarily coming from the judge.
Save money. Look better. Shop our sponsor Quince today and refresh your wardrobe with some new styles for spring.
Quince is our favorite clothing brand. They are all about getting you luxury styles at affordable prices. No markups, no middlemen, just high-value, high-quality fashion pieces that will transform your look.
They've got everything. Organic cotton and Mongolian cashmere sweaters, breathable linen, soft Pima cotton that looks great and doesn't pill, washable silk pieces. I mean, Quince is a go-to for me at this point. I love their work shirts and sweaters, and I can't wait to try out some of their new pieces for spring.
Same here. I'm really looking to try out their linen pieces as the temperatures turn warmer. But since it's still pretty chilly out, I'm relying on my Quince Mongolian cashmere sweaters to weather the changing seasons. I'm regularly wearing all of them, and they've held up so great despite my constant use. These things are great.
A wardrobe refresh does not need to break your budget. All you need is a few quality pieces that pair well and hold up. Pieces that don't go out of style. Quince has got you there. Check out their website today, because Murder Sheet listeners will get a great deal.
Right now, go to quince.com/msheet for free shipping and 365-day returns. That's a full year to build your wardrobe and love it. And you will. Now available in Canada, too. Don't keep settling for clothes that don't last. Go to quince.com/msheet for free shipping and 365-day returns. Quince.com/msheet. And I guess I just don't feel like that's a good use of a judge's time.
It's a very poor use of her time. What happened and the way we were treated by the Allen County outfit was deeply unprofessional. And I think it was a violation of some of our First Amendment rights. I don't think a judge has any business deciding who can or cannot cover
Also,
a trial.
the goalposts moved several fields because it started off you could not represent a podcast. Okay, fine. That's let's say that's a principled stance. Fine. Then it turned into, well, you can't even have any remote associations with a podcast, even if you're working with a print outlet,
be it a magazine or a
so it's like,
newspaper.
well, I hope any of the other journalists in line who have done podcasts or were part of her, I mean, like, hide your podcast, because I mean, if she finds out, maybe you're gonna get nuked too. Except you won't, because I think there's something going on here. But anyway,
yeah. So I mean, I'll be blunt. I think this is a real misuse of power. I think it's an abuse of power, not just as it affects us, but as it affects all the reporters covering this case, and as it ultimately affects the public.
Yeah.
Because this is also, there are poor benighted souls out there who don't even listen to us, but are interested in the case, and maybe they have their favorite outlets. And those outlets, maybe they deserve a place there too.
Here's the thing. The scarcity is frankly just an artifice. Allen County acts like it's behaving like a county that was asked to handle this a week ago, and they threw something together and it's the best thing they can do. I'm sorry, we can't get to everyone. We're just trying our best. No, they've known this is coming for months, and they've seemingly done nothing to prepare. And here's what I would have done. And I don't think it's Monday morning quarterbacking. I just think it's like common sense at this point. You know, they should have had the ability to set up a streaming situation where they could stream to a separate room that could have contained media. Here are the benefits of that, okay? And again, we all wanted cameras in courtrooms, but forget that. You can still have good access even if you don't do that. Set up a media room, have it be like as many outlets as you see fit can come in and out. They can type, they can talk, they can be on their phone to their editor, they can step outside and do a live broadcast without disrupting people in the actual courtroom. It's keeping everything separate, but they're able to view things and really take things in and understand them, and not be rushed and not be penalized for getting up and doing their jobs outside. There's that would have been the way to handle it.
That way, basically, everyone could get in, and maybe even members of the public could get in.
Hell, you could say murder sheet's not invited to that, even if they're with the Franklin Daily Journal. And like, I would still be so much happier about this situation, because I'd be like, okay, well, maybe she had an issue with us, but at least everyone else is getting what they need, and we're having good public access. I would be willing to write off what happened with us as a weird aberration, maybe a misunderstanding, maybe just overly stringent, whatever. But I feel like it's all symptoms of the same issue of lack of care around public access.
Yes.
And no leadership, but a strange amount of specific involvement.
Yes. I have pretty strong feelings about this, and I look forward to sharing them all with you. But I will suffice to say, I think what Judge Gull has done in this case is an abuse of power, and it's also a misuse of her time. Maybe she would have more time for all those murder cases she refers to in her order if she wasn't dealing with such things. With all of this said, should we move on?
Yeah, but let's talk a little bit. I mean, one thing. I mean, if you follow the show, everyone's constantly yelling at us. One week we're in the pockets of the defense. Another week we're in the pockets of the prosecution. Another week we're in the pockets of the judge. And so I just want to use this as a time, like, we'll say whatever we want based on what we think and based on our analysis of the facts of the situation. And that means pissing everybody off. So, I mean, that's fine. That's our jobs. It's not our jobs to do any hand-holding. If that being said, if we think somebody did a bad job in one respect, that doesn't necessarily mean we're going to just hold everything against them for the end of time. So, I mean, again, I really think Judge Gull has done some serious wrongs here and really bungled the public access version of this. But if she's doing a good job at trial, we're going to report that. If we feel like she's making reasonable rulings, we're going to report that. This doesn't mean that it's going to influence everything we think about her. It's just that we do feel the need to speak on this specifically for the sake of transparency and to let people know what's going on. And, it's same with the defense. I can say that, hey, maybe this filing that they did wasn't very good, but I can also say, hey, Baldwin and Auger did a great job in voir dire, right? So like you can, I think we all instead of treating it like it's a stupid football game, let's treat it more like we can kind of critique things and praise things based on what happens, maybe compartmentalize a little bit at times, and go forward in that respect. So I think did that kind of cover what you wanted to say?
Yeah. Shall we move on to the hearing?
Sure.
So 8:37 a.m., Richard Allen came in a striped shirt. He was wearing handcuffs at the time, but they were quickly removed. And all of this was outside the presence of the jury because it is important for his rights for him not to be seen in handcuffs in front of the jury.
You don't want to make a defendant look like a criminal, frankly, in front of a jury by having them in the prison garb, in the handcuffs, with the shackles. They need to look like a person. Otherwise, you could really prejudice a jury against that defendant. So that's why that's done and why it's different for trial and for things that are in the presence of the jury versus the pretrial.
Yes. He had glasses on his forehead all day, the last day of jury selection.
Never, ever used them at all. I wonder if he even needs them, honestly.
The glasses were still on today.
I'm actually legitimately curious, does he need glasses? Because I've never seen him use them, but he does always have them on.
So the first order of business was to discuss the motion by the prosecution. They don't want to include the sketches.
Yeah, it's a motion in limine, so that's like throw out mention of the sketches in the case.
Stacey Diener was in charge of that. Talk about Stacey Diener, talk about the witness she called.
Absolutely. Stacey Diener is, of course, one of the deputy prosecutors in the Delphi murders case. We've seen a bit of her so far. I like her. I like her delivery. She's very cool, unruffled, kind of very smooth, matter of fact. That's kind of the way she delivers things. That's the way she sort of conducts her portion. So I think her style works well in my opinion. The person she called was Thomas Plants. He is a retired special agent of the Federal Bureau of Investigation, as well as a forensic artist. He also is apparently a former Indiana State Police trooper and forensic artist. He had a background in commercial art and has then had a long career in law enforcement and retired only in March 2024. He does consulting now. He was an instructor. He's extensive background, including working at the Knoxville and Detroit field offices for the FBI. And he was the first and only, I think he was the first special agent in the FBI to perform forensic art for them. Basically, most of those people are civilians. It's rare that a special agent would be doing that, but his background, that's what he would do. And he was there to kind of talk. He was also notably involved in the Delphi case because he is the artist who drew up the first released sketch, which was the second one drawn, based on the witness sighting of Sarah Carbaugh. And this is, of course, the sketch that was, again, first released. And it's the one that looks like an older man that we're all familiar with, I assume. He talked about how he uses cognitive interviewing techniques. And that's basically where he's kind of encouraging people to kind of get back in the mode and be open to different almost like triggers with their memories in order to get back in the mode of giving him a really good description of somebody. So that could mean like kind of talking, like interviewing them extensively. Like, what were the smells that day? Like, what were you doing before then? Like, walk me through the whole, like, it's all these things to almost prepare someone to be able to give a really detailed sketch. Right?
Right.
And so he talked extensively about that. And I mean, should we talk about like what the state wanted versus what the defense wanted here? Because it was weird. There was a bit of an agreement in part, but
what did the state want?
The state is saying, and I think you explained it better to me, so I want you to jump in at some point. The state wanted the sketches, the two prominent sketches, the sort of so-called old man sketch and the young man sketch released in 2017 and 2019, respectively, to be kept out. And what their argument was essentially like the witnesses who gave those sketches identified the person they saw as the guy in the video that Libby took, that Liberty German took on the bridge.
So therefore, we don't even need the sketches.
So-
We just have them come in and say, the video is who I
The
saw.
video is who I saw. So I think you described it using a famous landmark.
So I said, Anya, imagine that you and one of your wonderful sisters took a trip to Paris and saw the Eiffel Tower. And then at some point as you are coming back from Paris, you talk to someone, you give them a description of the tower as you saw it that day, and they draw a picture of it, and you say, this picture is pretty close to what I saw. And then it turns out that your sister had a camera with her and took a picture of it the same day, the same time you were seeing the tower. So at that point, you look at the picture and you say, yes, this is exactly what I saw. And it's a photograph. So at that point, the argument would be, do we need the picture that was drawn anymore, or can we just rely on the photograph? And the state is saying we don't need to talk about the sketches. We can just rely on the photograph. And I think the defense's point of view is if investigators during the lifetime of this case were sending around a sketch of a person who did not look, in their opinion, like Richard Allen, and we're saying this person who does not look like Richard Allen is guilty of this crime, help us find him, then they feel they should be able to bring that up in the trial as part of their critique of the investigation. Because like, oh, hey, look, this guy they said did it. It's not our client. This sketch is different. So is that what the crux of it was?
But the defense also wanted to throw out the Sarah Carbaugh sketch because that's the one that frankly looks more like Richard Allen.
Yes. And so
they were like in agreement on that one.
So the witness was the person who drew that sketch. And the cross-examination was done by Jennifer Auger, who we haven't really seen a lot of. She did really well during voir dire. And this cross-examination she did today was really good.
Yeah, it was brutal. I mean, I was really impressed.
You have to imagine when you see a really good defense attorney in court that if you see them doing something that works, it's probably like at least a little bit of a bit. And so she comes up there and she's like acting like, oh, I don't know what page this is on or this is on. And maybe you're thinking, oh, I can relax. She's not really all that intimidating. And then as you relax, boom, she gets you.
Yeah.
She then suddenly just became a shark.
Yeah, I relate to that. You know, like I can't find anything, and then suddenly I'm saying harsh things. I feel like that's my life. So I mean, it was impressive because I think she definitely lured Plants into a trap, and you know, I could kind of see it like, like they've got something. So she, you know, one of the things that he talked about it was that you're not supposed to like show pictures of a suspect to the person who is going to the eyewitness, because then that might bias them and they might just describe the suspect, right? Like,
so yeah, if someone, if Anya is under suspicion for stealing cereal, and there's somebody who saw the serial thief, and the sketch artist says, "Oh, hey, look at this picture of Anya," now describes the thief, that might influence them.
Yes, and so what Auger kept saying was like, "Well, you'd never tell someone to cheat, would you?" Or like, you know, give them images or whatever. And Plants was like, no. And then
I'd obviously never do that.
She pulled. I was like, well, gosh. And I was like, okay, this is probably the time to hedge because obviously they have something. Like, there's another shoe waiting to drop here, sir. And she played the deposition with Sarah Carbaugh, and he talked about cheating. Now, I mean, I will get to what his explanation was, and he did. You know, he was talking with her about the image of Bridge Guy. Now, what he clarified was like, listen, I say cheat because it's like cheat codes. And he was talking about, he talked a lot about accessing memories, storing memories. So like, I understood what he was saying. He also was talking about like, when you have situations where it's like surveillance footage that's really blurry, it's okay to show that because you're trying to, again, elicit the context. You're trying to unlock those memories. It's part of the cognitive process. So in his view, the image of Bridge Guy is faceless. It's essentially so pixelated that you cannot make out the man's face. And I tend to agree with him. I think when people, for all those years, were like doing side by sides, it was frankly the stupidest thing in the world because it was like, no one can tell what this guy is. He's featureless. He's like so blurry. You can't do that. But at the same time, it was definitely like a really embarrassing trap to follow into on the stand, I thought. And I was just like, oof, like, it kind of just was like, it was pretty rough to see. But I thought OJ did a really good job of just kind of setting that up, and she was like, no further questions, like, like he was trying to explain, and she was kind of like, no, I didn't, like classic lawyer thing of like, I don't want to hear it, like, we're done. And so I thought good performance by her. Ultimately kind of futile. One thing to remember here is that I think with this filing, sometimes sketches can lead to the identification of a suspect, right? Sometimes if the sketch looks like me stealing the cereal, and people come, local police knock on my door, and oh, yep, that's her, and I've got a bunch of cereal. So that would be a situation where the sketches were truly important to the case. In this case, the sketches didn't do anything. The sketches had nothing to do with how Richard Allen was eventually arrested or came on the radar even. The sketches were fundamentally useless. I would say this is a good case study for why you don't release sketches, because sketches are so subjective. And this is something that Plants was very clear on. Sketches are an artist's rendering of a person's, potentially fleeting memory. They're highly subjective. They're not a photograph. They should not be taken as seriously as, frankly, everyone took them in this case, in my opinion. Because it's just like someone might look young to me, older to a younger person. Like, there's just so much, if I'm driving on the road, I might like get a glimpse and maybe get an impression, but maybe just the light is falling on the person's face in a weird way, and I think they have a beard, and it's just shadow. Like, there's all sorts of things. It's not an exact science, and that was something Plants was very much emphasizing. But the sketches were useless here, and they were seemingly, what came out today, sort of drawn up based on pretty fleeting, momentary kind of views by these witnesses. And ultimately, the state's contention is, both witnesses identify the person they saw as the bridge guy in the video. So what the state is saying is basically, I think what they're setting this up for is, if we can prove that Allen is the guy in the video, that's all that matters. The sketches are irrelevant, which I would agree with. If we're trying to get to the facts, the sketches are not that helpful. But I can also see where the defense is coming from, saying, well, you guys made a big deal of it, so it should be fair game. So that's where we are. They cited some different case law and whatever. It sounds like Gull is going to come on the side of the prosecution on this one, basically noting that in this situation, the sketches didn't ultimately serve any investigative value, and therefore, the video is enough. I mean, was that sort of, was there any more context or anything for that?
Yeah, she said that she was struggling to see how the sketches can be relevant to the case if they did not lead to an ID of Richard Allen.
I also thought it was funny that the defense was basically saying, like, well, we don't really want the Sarah Carbaugh one because that one had a bunch of problems with it and they did it wrong and all that stuff, which, but that is the one that looks like Richard Allen in my personal opinion. But they really want that young guy sketch from Betsy Blair because, that doesn't really look like him. And they think that one should be allowed in so that they can say, obviously, it's not him. They kind of agree on one of the sketches, but they disagree generally.
Then there was kind of an odd moment where Ms. O'Jay wanted to give the judge an exhibit on a flash drive, and Judge Gold did not like that. She said, "I can't, when the jurors are deliberating, I can't give them a flash drive." And Brad Rosie was like, "Well, what can you give them?" And he said, "Can't you just, if the jurors want to see something that's on a flash drive, a picture or a video, can't a bailiff just, stick it in there and hit play?" And there was an objection raised. Well, there's a whole bunch of videos on the flash drive, and Rosie said, "Well, can't they just be clearly labeled?" So that was interesting.
Was that at that point, or was that later on?
I have it in my notes at the end of this. At some point in the middle of that, there was a brief interruption where the jury came and was sworn in.
And so in total with the jurors, we had, I think it turned out to be 8 women and 4 men, and then 4 alternates who are 2 women and 2 men. So these people are about to undergo a pretty extreme ordeal. They will be transported with Jason Bodie and other officials from Allen County to a hotel and, kept away from everyone else. And it's just really important that, they be respected and protected by this process. So nobody should ever be speaking to a juror in this case under any circumstances whatsoever. No juror should be leaking or researching the case or listening to anything. So let's just hope that these jurors take this really seriously and that everyone else takes it seriously and we can just all get through this, because these are just everyday people that have been thrust into a pretty wild situation. So if we want our system to work, we need to protect jurors and we need jurors to take it seriously. So yeah, this is pretty important. So good luck to all of them. There's discussion with the sketches about like certain things can get thrown out, like oftentimes sketches that were based on like hypnosis. They were citing case law from the 70s. There's a lot of back and forth on this.
And ultimately the judge is taking it under advisement. She has to rule on it pretty quickly because the defense apparently, at least to the moment, is planning to talk about sketches in their opening statement, which is tomorrow.
Oh. I'm assuming Baldwin's going to do the opening statement because that's sort of what we've heard is something he often likes to do, takes the opening very, very seriously. So that's my guess. I don't know that for a fact, but yeah.
So that was it for the sketches. The next one was a very quick one. You may remember that the defense asked for the jury to be allowed to visit the crime scene. The defense withdrew that motion. So the jury would not be visiting the crime scene.
I wonder why they changed their minds.
Yeah, I don't know.
I mean, it's not like Richard Allen would have to go there with them. They noted that. So, who knows? But that's not happening anymore. I think it would have been a logistical nightmare and much more difficult than they said it would be. But, I mean, I could understand why they'd want to do that.
So the next one goes to separation of witnesses and who can be in the courtroom. Typically, or not unusually, if people are testifying in a case like this, you want the witnesses separated, and that means like if Anya and I are both scheduled to testify in a case, you wouldn't want Anya to be in the room to hear me testify if she hasn't testified yet, because Anya obviously would just repeat everything I say.
Obviously, that's what my job is here.
So what you do is you say, okay, Anya and Kevin cannot be in the courtroom. When Kevin testifies, Anya can't be present, and so on. So there's a separation of witnesses. You can't be in there until after your testifying is done. But there are exceptions, and the defense asked for one of their interns, a young man named Max Baker, to be exempted from that. He's scheduled to testify, I think probably about conditions at Westville. Mm-hmm. They say we really need him to help us out during the trial. So we'd like to see him be excluded from that and allowed to sit with us. And
McClellan did not object to that.
So that was allowed. And Nick McClellan, the prosecutor, wanted 2 people to be excluded and sit with him. One was investigator Steve Mullen, and one was lead investigator of Indiana State Police, Jerry Holman. And he said they both worked in different areas. If I had to choose just one, he said it would be Jerry Holman, but I would really prefer to have both of them.
Mullen apparently has been handling all the evidence organization, so having him would obviously be pretty important because he might know where things are, where even the prosecution might not know.
And Holman has been on the case
since the beginning.
So he has the big picture view, which can also be incredibly helpful. Gull allowed both of them to sit at the table.
So yeah. That's not surprising. And actually, McClellan even cited a case where you had a similar situation where an ISP investigator and an FBI agent were both allowed to do this in Indiana. And, it just seemed there wasn't really much argument against that made any sort of real impact, I think.
So the next motion to be discussed was a motion in limine filed by the defense concerning they wanted certain testimony related to Richard Allen in prison to be excluded. And they said, some of this would be, some of the testimony we like to see excluded comes from police who interviewed people at these facilities. Some of it comes from inmates, and some of it comes from prison guards. And he indicated the prison guards were from Westville, Wabash Valley, Cass County.
Maybe some of the other jails, White County.
And I found that really interesting because this testimony is supposedly be about Richard Allen either behaving in odd ways, to say the least, or making incriminating statements. And we've been led to believe that the odd behavior and the incriminating statements were basically in a relatively small pocket of time, like a year ago.
Yeah, which the defense characterized as indicating that he was sort of driven to a horrible state at one specific time, and then things changed and he was able to get better.
He got better, and then he went to Cass County very, very recently.
But it sounds like something happened in Cass County, too.
Yes.
So wonder what that was. And also, that would really, really hurt them in terms of their whole, like, he was kept in solitary confinement. That's why he's doing all of this. Because if he's in the place where they were begging for him to get sent, and he's still doing this stuff, then I don't know. That sounds kind of bad for him. I mean, like,
yeah, that was.
You could say, I guess he was broken and he never got over Westville, but I mean, I don't know. That sort of seems like maybe it indicates something else. It sounds like there's going to be a lot of stories, and listen, I'm just reading between the lines here. It sounds like there's going to be a lot of impressions from people who worked there that he might have been either malingering or that his behavior was based on something like a guilty conscience rather than an actual mental illness.
And by malingering, you mean he was faking it.
Faking it. Or, just, basically behaving in a way that did not actually fit what a mentally ill person would be doing, or that, he was in somewhat of control of his behavior. That's what it sounded like based on what the back and forth was. But we don't know that. It's possible to be some, but I mean, it seemed like the defense was trying to get ahead of something with this. Is that fair to say?
Yeah, and Rosie was saying, well, these people aren't qualified to make a determination about whether or not someone was faking bizarre behavior. McClelland says, well, they're not testifying as mental health experts. They're just testifying on what they saw and how they interpreted it.
I mean, I think I saw Rosie's point about, they shouldn't be able to diagnose him or anything like that. But at the same time, if you were working with him every day and at one point you see him doing something that could be qualified as a symptom of a severe mental illness, and then the next minute he's doing something that completely counteracts that and maybe even indicates that he doesn't have one, or that he's saying things like, oh, I'm he's in control of his behavior, then I think that would be relevant to hear.
And he indicated also he was concerned that if you're asking a person whether or not Richard Allen is faking bizarre behavior or faking it when he says certain things, you're basically asking for an opinion of their guilt or innocence. And he said, for instance, like, what if someone says, Richard Allen told me that he told the girls to go down the hill and then got scared and killed them.
Mm-hmm. Yeah. And McClelland pushed back.
We're getting more details about what's in these confessions.
Well, I mean, I thought he was just using that as an example. Or he got scared and killed them, yeah. But he may have just been speaking of, like, what if he says that, or do you think he was trying to basically, like, let that out so people can...
McClelland, in his mini opening, said that Richard Allen intended to do something else with the girls and then was interrupted. Perhaps whatever interrupted him scared him. Right.
Yeah, some sort of sexual assault was like the motive, and that he was interrupted, maybe scared. We're kind of seeing this all pieced together. I mean, I feel like the defense does something again and again where they sort of conflate two different things. So, I mean, it was weird that McClelland was like, we want to hear what these people saw. And then Brad Rosie's like, well, they're going to say he's guilty. And it's like, that's not really what it's about. It's about whether or not, they're making an issue of his mental health and saying that this is all because of either some combination of deprivation, mental illness, being pushed to the brink by these negative circumstances. But if the people who are observing him in those circumstances have something to say about that, that might be relevant to hear in order for the jury to determine, yeah, this is mental illness. Maybe these confessions should be not given much weight. It's like they want to just have everyone accept that he must be mentally ill without actually like necessarily hearing from anyone who is actually there. And so I didn't find their arguments on that particularly compelling, and as long as these prison guards aren't going to be saying, well, like, I diagnose him as whatever. I mean, I think that's I think it's fair to hear them out and see what they have to say, because it sounds like it might be interesting. Again, when they said Cass County, I thought I misheard for a second. I was like, what? And I
was really surprised.
I looked at your notes and I was like, no, that was Cass County. Like, that's very recent. If he did something in Cass County, that's pretty shocking.
Yeah.
But yeah, I mean, what do you make? Am I being too unfair to the defense there? Like, do you feel like they sometimes are like arguing against something that the state is actually not saying?
Well, keep in mind that they are aware of a lot more than what we are.
Obviously.
And they are aware of where the state might be going with something.
So they might be saying, some of this might indicate he's guilty, so we better cut that off of the pass.
Yeah.
All right. Well, I mean, I don't know. It sounds like this could be some pretty bad stuff for the defense. Maybe it's not. Maybe it's just neutral. Who knows? I mean, we're kind of speculating at this point.
What did Gull say?
Gull basically said, tell me if I interpreted this wrong, but basically that, like, we can hear out the prison guards as long as they're not diagnosing him.
Right.
Which seemed like a reasonable ruling to me. They shouldn't be diagnosing him. They're not qualified to do so. Like that would be inappropriate. And also, I don't feel like they should be saying, oh, well, he said he killed Libby and Abby, so therefore he did do it. Because you can falsely confess. They don't know that. They weren't there. They have no knowledge. But they can tell us about the behavior that preceded and followed some of these outbursts. They can tell them about the, what was actually said. I mean, that all seems fair to hear from them. And again, like if some of this is just mental illness, then I would think that would be something that would be bolstered by hearing from people who are actually seeing this unfold.
So the next one involves a discussion of a lawsuit that the prosecution did not want the defense to bring up. This is a lawsuit about conditions, and it resulted in change to Department of Corrections policy about mental health. And it got a little bit heated. Stacey Diener argued for the prosecution, basically saying this is a lawsuit that was over even before Richard Allen even set foot in the department.
It ended in 2020, I think?
Something like that. So how could it be relevant to him and his situation?
That seemed like a fair point.
And Rosie argued, well, it set up this policy for how people with certain mental illnesses should be treated in the Department of Correction. And I feel it is important for people on the jury to understand that and get the full context so they can really understand the situation.
So it's about getting the jury the truth. I think it's actually more about just making Indiana Department of Correction look bad. So the jury is like, yes, it is their fault that he confessed, which is fair. That's the defense's job to get that in. It got heated because there was some bizarre catch-22 sort of situation where Rosie and Gull file. This happens a lot. I feel like Rosie and Gull are often, that's when things are getting heated if they're starting to go at it. Because Rosie has kind of a temper, and then Gull is just like kind of icily repeating things. They get into a cycle sometimes, and so is that fair?
Yeah, she said Rosie was like harping on an issue.
Yeah, she's harping on an issue, and it just like she's kind of like
a real edge to her voice.
She sounds disgusted. He's like losing it, and it's just kind of like this uncomfortable. Everyone else is just sitting there like, okay. So what happened? I mean, I didn't really understand his point, so maybe you can explain it, Kevin, if you felt it was more reasonable than I kind of interpreted it as, because again, I'm a dumb journalist. He may have had a really good point here, but he seemed to be saying, I want to use this definition because they need the whole context of this, frankly, what sounded like an irrelevant lawsuit. And she's saying, but if that language was adopted by the time that Richard Allen was incarcerated there, why don't you just use that language in sort of like, I guess, like the official rule book about how they're supposed to treat people with mental illness. And then the defense kind of was like, well, we could kind of do that, but we need some, like, I don't know why they just didn't go with that, because that seemed to make a lot more sense. And then this just was like, no, but they need everything. And it was like, I don't know. I mean, what was going on here?
Well, Gull ruled that it was inadmissible, so it won't be included.
But what is your take on that? Why did they want that specific aspect so bad? Was it just to bring in like IDOC is a horrible place, and
I think so.
The people there, they should never, they were torturing him and all this stuff. But like,
And look, they did this other stuff too in the past.
This is what it felt like.
I could understand why a defense attorney would want to.
No, I mean, I'm more power to him. I mean, like, that makes sense. But I also can understand why that would get ruled out, because it's not relevant. I mean, you got to try, right? You mean, like, you're not going to get anywhere by not trying to get more in and more context and more things to make your case seem stronger to the jury. So, I mean, I'm not faulting them for that. I'm just more of saying I didn't really get, like, the argument against it being kind of irrelevant.
As I said, Gull ruled it inadmissible.
But yeah, things had been pretty collegial for a while between the parties. There were, at one point, I mean, the most, like, brutal moment in this was the ending, where it was actually sounded collegial but was not. Rosie just, like, kind of like you could tell, like, kind of like almost like kind of raised his hand and was just like, thank you. You know what I mean? Like, he was obviously not thankful or happy about this. And she just very coldly responded, "You're welcome." Like, did you notice that? I was like, oh man, like, tension. The next portion was all about ballistics.
Yes. The prosecution filed a motion in limine saying that Bill Tobin, a defense expert, should not be allowed to testify. And this was handled by Jim Luttrell. And he is a very unusual attorney. He may be the only attorney in the world that is not in love with the sound of his own voice.
Attorney burn.
He is very, very concise and to the point.
Well, I appreciate it, because people are talking a long time in some of this, and frankly, they're just saying the same things over and over again.
Well, he didn't repeat himself. He said this guy isn't a ballistics guy. He's a metallurgist. He doesn't really even think that ballistics evidence is real.
He said, no, it would not be worth my time in terms of doing any work around forensic examination of firearms.
Tobin said that.
Tobin said that, not Luttrell. Tobin, he quoted Luttrell. He quoted Tobin as saying that. And he also quoted Tobin as saying he never did, quote, research on what he considers a flawed methodology.
Yes. And Luttrell said it would be confusing to the jury if this guy comes in and just says that all ballistics is junk science. And then Rosie stood up and had a really lengthy response.
This was endless. This was like I felt the longest portion of the whole thing. And frankly, it felt like he was repeating himself an awful lot. I think I understand that. I probably repeat myself too much on this show, frankly. But I think when you're in court, it's often better to be a little bit concise and just kind of, go with that, make your point and get out of there, because it didn't make his point sound any better, saying the same thing over and over again, which was metallurgy is the source of tool mark evidence, and tool mark evidence is the source of forensic evidence. And it's all about metallurgy and statistics. Oh man, this guy Tobin, he knows statistics. And you know what? That's important, because it tells you about forensics. And it's just like, okay, we got it. We got it the first time. It went on for a long time. Did you feel he made any good points in there that you wanted to reflect upon?
I think you summarized it pretty well.
It was a lot about, and there was like, it doesn't matter that he doesn't do forensics, and that's not doesn't do forensic examination, and it just, basically like knocks the whole discipline. It's okay because he does metallurgy, and I was like, okay. I mean, I think there's a growing trend of skepticism. No, I shouldn't say growing trend. There was a growing trend of skepticism around tool mark evidence. When you talk to forensic examiners, which we have done, we've talked to skeptics and forensic examiners. So we've heard this from both sides. Skeptics do tend to say it's all bad, throw it all out. Forensic examiners talk about how, maybe a while ago, people were getting too comfortable making too strong of declarations in court. And that has largely been amended by the fact that there have been more, reforms and things that have come about as a result of some of the scrutiny. And so those are sort of the two sides. I mean, the fact of the matter is the defense is going to have someone who does believe in forensic firearm examination be there on their side, a Dr. Warren. And so I think part of the prosecution's point was like, it's weird to just knock the whole thing, but also have this guy. And, and one of Rosie's big points was like, well, Dr. Warren thinks that Bill Tobin would be great, kind of, because he thinks that statistics and metallurgy would be very helpful to know in forensic examination. And later on, Luttrell pointed out, like, well, in the deposition actually kind of indicates somewhat differently. Like, yes, he did say statistics would be helpful, but he didn't indicate that he thought Bill Tobin would be a great fit for this.
Yeah.
So I thought it was funny. They started arguing about that case out of Cook County that everyone cites about how, like, forensics was really, ballistics was very much kind of like thrown out there, and it was like a big deal. And they were going back and forth. And what did Luttrell say at one point? He was just like,
and also Rosie brought up a Maryland Supreme Court case, I believe, that made a similar ruling, and Luttrell said those cases are outliers.
They're outliers. They don't apply here in Indiana, and they're outliers. And that he made some like quip where he said he objected to it being a good idea in Cook County, like the ruling being a good one. I felt like he also made the point that seemed kind of important, that Tobin has testified in a lot of situations like that. It seems like when it's like at a higher level, but he hasn't done a lot of jury trials.
Yeah.
So he's coming in, I think, maybe more to talk to the higher courts and say, here's my take on ballistics as a whole. And when it comes to the jury trials, though, that's not often as much of the case, because the trial courts don't necessarily look on ballistics so unfavorably.
Yeah.
I think, it kind of depends. And he just indicated that, like, the appellate courts just aren't really there in Indiana. So that was the back and forth there.
And Judge Gold took that one under advisement.
Oh, they brought up Caden Smith again.
Oh, yeah. And Rosie said, I'm sure that it's just a coincidence that this happens to be a case that Andrew Baldwin
They're
worked
so
up.
salty about him bringing that up. They were like, oh yeah, and Caden Smith, and that was an opinion that it was only like 6 lines, and who cares, it's Marion County, blah blah blah. So that was kind of funny.
So Gold takes that under advisement. And then Prosecutor McClelland said he doesn't like the idea of trial by surprise. And the defense have recently added several witnesses without explaining to the prosecution what they intend to testify about. He mentioned former prosecutor Rob Ives, Neil Bruin, and Stacey Eldridge.
Neil Broom is a computers expert who actually worked on the case in Honolulu that we randomly covered, not knowing the connection there, where there were a bunch of corrupt police officers, corrupt police chief, corrupt prosecutor, the K Aloha couple. And he was in the newspaper coverage, he kind of comes out and is like, oh, well, this is what this phone does, and like this might indicate that this photo wasn't really taken at this time. And then the prosecutor points out, like, yeah, but can't you just like edit that easily? And he's like, oh, well, yeah. So I don't know. I don't know. Maybe that was an outlier for him. And then Stacey Eldridge, she's also supposed to talk about this kind of, I guess this recent discovery from the Cellbrite phone that they got August 22nd and August 23rd from Libby's phone. The defense is often making a big deal about this in order to, show that, I think what they're trying to do is like maybe play with the timeline on the girls a little bit when they were killed. And
so ultimately it was agreed that these new witnesses should expect some sort of call from Prosecutor McClelland where they discuss, at least in a cursory form, what they intend to testify about so he can prepare his cross-examination. Well, Neil Broom, it's funny. He got a hold of Neil Broom. Neil Broom would not tell McClelland what he was going to talk about and, said that it would be a violation of his client's rights. And then Eldridge indicated, I don't know what I'm going to talk about. It's too soon to say, basically. So it's interesting. It seems like they may have gotten these folks maybe, I don't know when they did, but like it seems odd if one of them doesn't know what they're going to talk about, because trial's tomorrow. But I don't know. Maybe they're kind of doing some stuff on the fly, I guess. And then I want to mention a bit of a scary moment at the end where a bit of a cliffhanger for a moment, but Judge Gold definitely made the right decision here.
Mhm.
Give her her due. You know what I'm going to say?
No,
You have no idea what I'm going to say.
I have no idea what you're going to say.
So Jennifer Auger asked, when you accepted our offer to proof on the Odinism, does that offer, and then when you accepted that our offer to proof on Odinism can come from the hearings from the summer, did that offer of proof in your mind also include the testimony of our expert witness, Don Perlmutter?
Oh, no, yeah.
Because if Gull said no, that meant Don Perlmutter would come back and testify again for 3 or 4 hours. But Gull said, yes, it did include it.
So we're good.
Yes. Great ruling by Judge Gull.
Yeah, that was important, and that was, geez. Well, I mean, I guess that's it
I'm done.
We're done. So let's, tomorrow, first day of trial. We're gonna be there.
We're gonna do our best to get in.
We're gonna be there.
As you know, we don't have press passes.
We don't have press passes, but we don't need press passes. We have done a lot in this case without relying on press passes and only relying on our determination to try to do a good job. And so hopefully that will carry us through. We may be slightly, like limping to the finish line by the end of this thing. But, we appreciate you listening and taking the time. We're giving you our sort of opinions to a certain extent on some of this, but we're also just trying to get you the facts, and you can take our opinions or leave them. You can just take the facts. Either way, we're just trying to give you a comprehensive version of what's happening and trying to clear up along the way some of the misinformation that inadvertently or frankly advertently on purpose gets kind of injected into the bloodstream here. It's an important case. The families of these victims deserve a smooth process with facts coming out. And I think Richard Allen deserves a fair trial. And I think, we're just determined to, again, improve the public access by giving you these detailed reports. We'll be doing this daily throughout the trial. So just tune in.
Assuming we get in.
Even if we don't get in, we have backups because we have people in the courtroom that we'll be able to get some info from. So I guess just tune in, but I'm confident we're going to get in. Anyways, thanks very much for listening.
Bye.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
Want a game-changing way to watch college basketball? With a one-day pass from Sling, get instant access to the men's and women's tournaments starting at just $4.99. You can catch all the action on TNT, TBS, ESPN, and ESPN2. Want even more hoops? Then add an extra pack to your subscription for just $1. No overpaying, no overcommitting. Just tournaments so crazy, they be crazy to miss. Visit Sling.com to learn more. Sling lets you do that.